All right. Hello, everyone. Welcome, welcome. I'm Jacqueline Dalton, Director of the Health Equity Community Collaborative at Health Leads, and I'm excited to welcome you all to today's webinar, Understanding the Legal Attacks on Racial Health Equity Programs. As you are joining us, I invite you to share your name, your pronouns, organization, maybe an emoji about how you're showing up to this conversation today, and even the place that you're joining us from. I know that many of you are joining us from the West Coast, like California, maybe the South, Texas, or Georgia, from the Midwest, particularly Michigan and Illinois, as well as the East Coast from states like Massachusetts, Maryland, and New York. So please let us know where you're joining us from today as you introduce yourself as well. Before we jump in, just a few housekeeping items to begin. We do have closed captioning available for this webinar. To enable the captions, please click the CC icon at the bottom of the screen and then live transcript, and you should see those captions pop up. During the webinar, we welcome comments in the chat as many of you are already starting to do as you're introducing yourself. So please feel free to use the chat function throughout the webinar. And we also welcome you to submit Q&A or questions through the Q&A button at the bottom of your screen as well. We received many questions from the registration, but we welcome any questions that you might have pop up as well. So just at the bottom of your screen, you can click the Zoom Q&A feature and submit your questions or type your questions into that box as well. The good news, right, is that this webinar is being recorded and it will be shared with everyone who has registered for the webinar in our post-webinar email. And then last but not least, at the end of the webinar, we will be launching a poll or evaluation survey. So please take the time to quickly share your feedback on today's webinar, as well as suggestions for our future webinar offerings. Now, I'm going to quickly just mention some of the goals and then mention our speaker lineup for today. Today, we're hoping to really learn a lot about the current racial health equity legal landscape and legal risk. Many of you have been interested in that from feedback that we received in previous webinars. So today we have brought to you the speaker lineup today. We also want to recognize the things that you have shared as far as the opposition's approach and fear that has kind of emerged from that around racial equity programming. And then third, we want to identify federal, state, and local laws around some of these programs that many of you are running in your local areas and what may be the implications of some of those programs. And so for today's speaker lineup, we have Dr. Philip Alberti. He's the founding director of the AAMC's Center for Health Justice and the senior director for health equity research policy at the Association of American Medical Colleges as well. Dr. Alberti will be our moderator for today and will be providing us with a brief overview as well before we jump into our main presentation. And that will be coming from the Legal Defense Fund team. We have Ariel Humphreys, who's the Assistant Counsel at the Legal Defense Fund, Amalea Smirniotopoulos, the Senior Policy Counsel and Co-Manager of LDS Equal Protection Initiative. And then we also have Pilar Whitaker, the Special Economic Justice Counsel at the Legal Defense Fund. So we're all really excited to hear from them today. So without further ado, I'm going to go ahead and hand it over to Dr. Alberti to kick us off with a brief overview. And you're on mute, Dr. Alberti.
I am, as always. Thank you. Thank you, Jacqueline, for the introduction, and welcome everyone today for this webinar on understanding the legal attacks on racial health equity. My name is Philip Alberti, and I am honored to be moderating the conversation and even more excited to be learning alongside all of you from the incredible panelists from the Legal Defense Fund. Thank you to the Health Equity Collaborative, to Health Leads, and a special shout out to Dr. Rhea Boyd for bringing us all together. So my job in these first 14 or 15 minutes is to introduce some concepts and frameworks to clarify how current and potential legal actions and rhetorical attacks strike at the heart of our common goal to ensure that all communities, and particularly communities made marginalized and minoritized, have a genuine opportunity to thrive. So I'm not a lawyer and I'm not a lobbyist, that I've spent the last 25 years as a population health and health equity scientist focused on creating sustainable, evidence-based, community-driven policy solutions to racial and other health inequities. So I also hope to spark a conversation about tactics and solutions to achieve our goal of racial health equity, even in the face of current headwinds. So at our Center for Health Justice at the AAMC, we say that health equity is our goal and health justice is the path that gets us there. And so I'm going to briefly unpack each of these, I think, deceptively simple sentences. But before I do, I want to take a quick pause just for the word equity itself. I think about our equity and racial equity work in three ways. I think about equity for populations within an organization. So our traditional EDI work around pay equity, promotion equity, equity in who gets admitted to an institution. I think all of our organizations, regardless of the sector they're from, should be and are concerned with this flavor of equity. And it's the flavor I think that's come under so much scrutiny and attack of late. Healthcare organizations also have to think about healthcare equity, right? Ensuring all populations of patients have a genuine opportunity to access and afford high quality, effective healthcare services. And finally, all organizations, again, across all sectors, should also be thinking about health equity across our communities, whether we define those communities geographically or sociodemographically. And I say all sectors because medical care only accounts for 15 or 20% of what makes a person or a community healthy. So we all have a role to play. The movement of health equity demands multitudes. And so when it comes to that final flavor of racial equity, population health equity, we start with this lodestar definition from the CDC, that health equity is a state where all communities have a fair and just opportunity to achieve their highest level of health. Now, the boldface text is my own. I really like to stress the importance of the word opportunity, that health equity is about genuine, authentic, equal opportunity and not about equal outcomes. So I propose that if the opportunity is real, if the opportunity is genuine, then the more equitable health outcomes, the more equitable economic outcomes or education outcomes, et cetera, will follow. So why do I stress this frame of opportunity? I think it's essential to understand the root of some of the attacks, both legal and rhetorical, on health equity generally and racial health equity specifically. So those whose values run perpendicular to health equity, those who levy attacks against the movement mischaracterize health equity's strength, right? That is our work's commitment to all communities having equal, genuine opportunity for health. And they say just the opposite, right? That we're forcing equal outcomes, that we espouse some kind of Robin Hood health justice that takes health from community A to give it to community B, that there are winners and losers in health equity. And that therefore, as you can see from this quote, we are somehow un-American. So as we learn together today, I urge us to consider how to frame our work, our policies, our measurement, and even our marketing around opportunity, racial justice as opportunity. But what does the state of health equity look like on the ground? Right? What does it mean for a community to provide that fair and just opportunity for health? So we in the center were early adopters of the Vital Conditions for Health and Well-Being framework, a model that has since been adopted by over 50 federal agencies and departments as an alternative of sorts to the Social Determinants Framework, or SDOH framework. So unlike the SDOH model, the Vital Conditions model puts the outcomes we want front and center. So rather than kind of a vague, we're going to address housing as a social determinant, the goal here is for all communities to have humane housing, to have reliable transportation, to provide a thriving natural world, right? The Vital Conditions frame keeps that end in mind. And so it's also more inclusive because at the very least, all of our communities want these things, these basic vital building blocks for themselves. It also stresses the importance of collective civic muscle and belonging, of civic engagement, including voting and law and policy. It's what binds the wheel together and what makes the legal attacks against this work so potent. And it also explicitly reminds us that the work of health equity is collaborative and multi-sector, right? To achieve racial health equity, all of us are necessary. You can see all the different sectors called out around that wheel. So for us at the center then, health equity will be achieved when all communities have and provide the basic vital conditions and services that we all need to thrive. So what stands in our way? Why can't we describe our communities in 2024 as having all of those characteristics that we saw in that vital conditions wheel? So my training back in the day focused on social conditions as fundamental causes of disease. So which social conditions? all the isms, classism, racism, sexism, etc. These isms, represented here by this hydra, are fundamental causes of disease for three reasons. First, they control which groups have access to crucial health-promoting resources like power, voice, information, beneficial social connection, etc. Which groups have them and which groups don't. Second, they impact multiple outcomes across multiple sectors. So think about all the research out there about the harm done by racist policies and practices like segregation or redlining, right? Segregation impacts health. It impacts educational attainment, wealth accrual, etc. So one cause, one fundamental cause, many outcomes. Third, these causes are nimble, right? They're clever. Even if you close off one pathway through which they exert influence, even if you chop off one of the heads of the hydra, a new pathway emerges. So for me, Michelle Alexander made a fundamental cause argument in her book, The New Jim Crow, right? Slavery becomes illegal? Well, a Jim Crow head pops up. Outlaw Jim Crow, and a mass incarceration head pops up. That is racism functioning as a fundamental cause of disease and inequity. And so these isms get baked into what my friend Daniel Dawes calls the political determinants of health. And we don't have to look too far in 2024 to see examples of the isms in our policies. From voter restrictions to don't say gay laws, the power of policy to deny groups opportunity, to maldistribute across our communities those vital conditions for health, it's a peril, maybe it's even a goal of the legal attacks on racial health equity. So just to connect the dots explicitly, healthcare restrictions unjustly remove basic needs for health and safety for women and for the trans community. Racist voting restrictions differentially weakens our civic muscle, and don't say gay policies erode belonging, erode community. So how do we counter these attacks? How do we achieve racial health equity given these headwinds? So our center says through health justice, which we have operationalized as keeping one foot, our process foot, grounded in community wisdom and multi-sector partnership, the other foot, our action foot, in an evidence to policy imperative, and then walking with both feet toward health equity in an explicitly anti-racist and anti-discriminatory way, which for us at the center means a focus on power. Who has the power at our decision-making tables to decide which research questions we ask, or which policies we interrogate, or whose knowledge and wisdom is incorporated into our work? So this process of community engagement in service of co-developing evidence that can be baked into policy and practice change at all levels, organizational, local, state, and federal, is as important as the goal of racial health equity that we aim to achieve. It's how we achieve that goal. And so to transition to our panel, and to maybe set up a conversation during the Q&A about strategies and tactics that we may consider to withstand these attacks and to bring more people into our racial equity tent, I want to briefly present some of our center's research on public perspectives on reparations in America. So when we published this brief in April of this year, there were 11 states and 22 localities across the US that were considering reparative justice action or task forces. Now, this is already out of date and doesn't include Chicago, for example, which recently announced the creation of its own task force. Now, California has led the way, and in June of 2023, their commission released a reparations report that presented well over 110 policies from across the sectors in that vital conditions wheel that would have a positive racial justice and reparative justice impact. So we at the center selected 7 of those policies to test in a public opinion poll that was nationally representative of US adults. So our sample size was over 10,000 and allowed for state-by-state estimates. So the first thing we did was just gauge support for these 7 policies. We didn't mention reparations, didn't mention racial justice, racism. We didn't even mention California. Just here are the policies. Do you support, yes or no? So all 7 policies were supported across the board, across all demographic groups, across political ideology. Right? In fact, there wasn't a state, a red state, a blue state, a purple state in the union where support for these policies dropped below 60%. So the kind of policy that would support racial justice is very popular, at least when you don't mention California or racial justice. And maybe that's not a surprise, but then we did something I think is a bit clever. We split the sample in half, 5,000 and 5,000. And for 3 of these 7 policies that could be rolled out incrementally, kind of bit by bit, rather than all at once, so environmental hazard screening, student voter registration for civic engagement ed in high schools, and clinical trial diversity, here's what we did. So all 10,000 in the sample got a little blurb about resource constraints, meaning that we have to prioritize the rollout, the implementation of the policy. And then we split that sample in two. And I'll use the voter education in high schools as the example. And we gave each half a different implementation plan to consider and respond to. So half were told that in the rollout of the plan, we would prioritize schools in voter turnout deserts, which is a real thing, where folks tend to vote less. And due to many reasons I'm sure all of you understand, racial and ethnic minoritized communities are more likely to live in these turnout deserts, though we didn't say that, right? So there would be a reparative justice impact, but it wasn't made explicit. The other half of the sample were told that we would prioritize schools in Black and Brown communities, given the evidence and history of well-documented voter suppression, etc. Now, I'm sure you can correctly guess which rollout plan was more popular. Right across all three policies that we did this with, the racial justice focused option had double-digit less support than the rollout plan that did not have that racial justice focus. So universally popular policies garner less support when we put our racial justice goals front and center. Again, that's probably not a surprise given the society in which we live. But that story isn't quite so simple, because depending on the state and depending on the policy being tested, the difference between the support for racial justice focused and racial justice not focused policy implementations varied widely. So let's just look at one state. Let's look at Arizona. So in Arizona, there was a huge difference in support around environmental hazard screenings for an implementation plan that prioritized racial justice versus one that didn't, a 16% difference. Whereas that difference was negligible, kind of within the quote unquote margin of error for voter registration and civic engagement in high schools. The implementation plan didn't matter so much. So the relationship between place and policy and framing is complicated. And again, it speaks to the centrality of local community engagement and co-development in the creation not just of the policy, but in the messaging, the marketing, and the communication of the policy. And so to me, ever since that poll, and maybe even well before, this question on the screen is kind of the central challenge to all of us in the health equity movement, right? I truly believe, as I know all of you do, that racial health equity benefits all communities, right? All of us. As Dr. Kamara Jones says, racism saps the strength of the whole society. And so then the opposite must also hold, that promoting racial justice strengthens all of us, all of our communities. So the challenge for us is to continue to show it, to keep building the evidence, to evaluate policies with that universal outcome in mind, to make our tent larger while holding on to our values, our principles, and our goals. And that is no easy task in the current legal and political environment. And so with that, I will stop sharing and turn it over to my colleagues at the Legal Defense Fund.
Thank you for that amazing introduction and table setting, Dr. Alberti. Good afternoon again. My name is Amalia Smirniotopoulos, and I'm here today on behalf of LDF, which is the nation's oldest civil rights legal organization. LDF has fought for equal access to higher education, employment, and healthcare, among other issues for Black people for more than 80 years. LDF is a nonpartisan organization, so we do not support or oppose any particular candidates, although the issues that we're talking about today are very much at the forefront of many political discussions across the country. And unfortunately, the challenges that we face will continue regardless of whether we're in a pro-civil rights or an anti-civil rights administration after November's election. During our presentation today, we will not be giving legal advice. If you need legal advice based on your specific circumstances, we encourage you to seek a lawyer. And we're also not going to give advice based on particular laws in particular states, although we will talk briefly about state-level legislation. Our goal today is to provide you with an overview of how courts analyze programs where there's a claim of racial discrimination against a health equity program. We're not going to go into as much detail about other possible challenges, raising other claims such as religious discrimination or free speech claims, which have also been used to challenge public health restrictions and healthcare programs with varying degrees of success. And we also know that in addition to attacks on racial equity, we're seeing challenges to access to care for pregnant people, LGBTQ+ people, and other groups. Those legal challenges are governed by related but different legal standards. We're tracking those challenges closely, but they're not going to be the focus of our discussion today. Next slide. So first, we want to start by defining some of the key terms that we'll use throughout the program. Next slide. So courts often talk about whether a program is race conscious or race neutral. And this distinction is important because it affects how courts analyze whether the program is legal. For the purposes of this presentation, when we say race conscious, we mean a program that explicitly considers race as a factor in a decision. And when we say race neutral, we mean a program that does not explicitly consider race as a factor in a decision. However, this distinction is important because race neutral policies do not receive the same degree of scrutiny as race conscious policies. And many health equity programs, such as implicit bias trainings, research on the impacts of redlining or racism on health, are in that race neutral category. Next slide. Affirmative action is one kind of race conscious program, and it's actually a fairly broad term that encompasses a variety of different race conscious programs. It describes programs in which employers, medical schools, and other institutions consider race as a factor in order to remedy discrimination, or in the case of higher education, to achieve the educational benefits of diversity. Importantly, just because a program considers race does not mean that it's unlawful, but courts will give it a harder look, and courts have found in some recent cases that race-conscious programs were not justified. Next slide. Diversity, equity, and inclusion, by contrast, is a broad term that encompasses a variety of different programs, everything from anti-discrimination training to affinity groups, targeted recruiting, mentoring. And importantly, most DEIA programs are race neutral. They generally do not involve any kind of quota or any kind of race-conscious decision-making. Next slide. Finally, before I turn it over to my colleagues, I want to give you all a quick crib sheet on how to understand the impact of particular legal challenges as they're coming up. So the first question is, when you're hearing about some new challenge, is to ask yourself, is this actually in court? Some opponents of civil rights have been able to shape the public narrative by filing bare bones complaints with federal agencies like the Office of Civil Rights at the Department of Health and Human Services or the Equal Employment Opportunity Commission without actually going to court at all and having to raise legal claims in that venue. The next question is, which court made the decision? So we're going to focus on federal cases, and I'm going to talk to you about federal courts. So only decisions made by the U.S. Supreme Court control all of the federal courts in the United States on federal issues, as well as state courts. By contrast, decisions made by a federal circuit court, which is the sort of intermediate middle court, only control federal courts in a specific group of states. But many of the decisions that we've seen to date have been made by district courts. And federal district courts don't control any other courts at all, although their reasoning could help persuade other courts to rule in the same way. The last question you should ask is what the court actually decided. So as we'll talk about throughout this presentation, several lawsuits have failed at early stages based on procedural grounds. Like if the person who filed the lawsuit, who's known as the plaintiff, did not have a right to sue because they could not show that they were sufficiently harmed by the defendant's actions. This is a legal concept known as standing. And what that means is that the court never actually reached the legal merits issues in the case, and so did not make any decisions about whether the conduct that was challenged violated the law or not. Assuming that the court's decision was on the merits, then you look at the reasons why the court made its decision, what statutes it was interpreting, what standards it was applying. We've seen our opponents try to stretch the meaning of certain decisions and apply them to new contexts when the court really didn't rule on those issues at all. And then finally, we look at whether the decision was a preliminary decision, which carries less weight, versus a final decision. So with that overview, I'm going to turn it over to my colleague Ariel, who will walk us through a brief history of the law governing racial equity programs and some of the different statutes and legal regimes that cover them.
Thanks, Amalia. So my name is Ariel Humphreys, and I'm an assistant counsel at LDF. I'll provide some of the legal background before my colleagues describe what the current legal attacks on race-conscious programming look like and how we can address them. Next slide, please. So I'll be answering the question, how did we get here? Next slide. And I want to start with the US Constitution. The Equal Protection Clause of the 14th Amendment says that no state shall deny any person equal protection of the laws. And so this provision enshrines a constitutional guarantee of racial equality. The 14th Amendment applies to government actions. It does not apply to private parties. So it would therefore apply to the actions of a state or local agency, a hospital run by the government, or a state medical school, but not to private healthcare organizations, including nonprofits, except in limited circumstances. In order for such government programs to lawfully consider race when making decisions, the government must do two things. First, they have to serve a compelling government interest, and second, they have to be narrowly tailored to meet that interest. That standard is known as strict scrutiny. Now, although the 14th Amendment was designed to right the historical wrongs of slavery, opponents of civil rights have long framed any effort to remedy racial barriers and expand access to opportunity as itself a form of racial discrimination. So next, I'm going to describe 4 relevant federal anti-discrimination laws that govern healthcare. So that would be Title VI, Title VII, Section 1981, and Section 1557. Next slide, please. So starting with Title VI, which states that no person can be excluded from a program or activity receiving federal financial assistance on the basis of race. Program or activity is defined broadly and includes all operations of state or local governments if any part receives federal financial assistance. So that could include a grant, a loan, donations, etc. Title VI thus provides broad protections in a range of areas that receive federal funds, including healthcare. Although the U.S. healthcare system is largely privately owned and operated, many healthcare facilities are still covered by Title VI because they receive federal financial assistance, whether it be by participating in Medicaid or receiving federal research grants, for example. As a result, Title VI may cover private hospitals, mental health centers, clinics, treatment centers, and more. Title VI has also been an important and powerful tool historically to create more equitable healthcare systems. When Medicare and Medicaid were enacted, Title VI was then used to desegregate U.S. hospitals. And HHS has issued regulations to effectuate Title VI. Those regulations state it is permissible to consider race when a recipient of federal funds previously discriminated and is taking steps to overcome the effects of that prior discrimination. But even without such prior discrimination, a recipient may take affirmative action to overcome the effects of conditions which resulted in limiting participation by persons of a particular race, color, or national origin. And just a note about how Title VI is enforced. Private parties can bring Title VI claims for intentional racial discrimination, which is known as disparate treatment, but only government agencies can bring disparate impact claims under Title VI. Disparate impact discrimination occurs when a race-neutral practice or policy has a disproportionately harmful effect on a racial group or other protected group under Title VI, and that disproportionate impact cannot be justified. Next slide. So moving on to Title VII. Title VII prohibits public and private employers, including healthcare organizations, from discriminating on the basis of race in employment decisions. It applies to private sector companies with 15 or more employees, same for state and local governments with 15 or more employees, as well as the federal government, unions, and employment agencies. Under Title VII, employers have a duty to root out racial discrimination, including eliminating policies and practices that create unfair barriers to employment for people of color. Like Title VI, it prohibits both disparate impact and disparate treatment, but unlike Title VI, private parties can also bring those disparate impact claims. Next slide. So Section 1981 is another anti-discrimination law, and it prohibits racial discrimination in the making and enforcing of contracts. The Supreme Court has held that it prohibits racial discrimination against all groups, which means that people of any race can bring a discrimination claim under Section 1981. Like Title VII, it's often invoked in cases of workplace discrimination, but it has some distinctions from Title VII. For example, it only applies to cases of disparate treatment, which is intentional discrimination. It also does not cover certain categories like gender discrimination. I also want to note that contracts can cover things outside of the workplace. Next slide. Finally, Section 1557 is the non-discrimination provision of the Affordable Care Act. It prohibits discrimination on the basis of race, national origin, sex, age, or disability in any health program or activity that receives federal financial assistance. HHS issued a rule in July 2024 pursuant to this section, which includes provisions that, amongst other things, required covered entities to take remedial action if they have been found to have discriminated, and also permits voluntary non-discriminatory steps to overcome the effects of the conditions that limited an individual's ability to participate in a health program or activity based on their race or other protected characteristic. Section 1557 also cross-references Title VI, and this is evidence of the congressional intent that Section 1557 would have the same meaning, and so would likewise prohibit both the disparate impact and intentional discrimination. Taken together, these laws are designed to address racially discriminatory practices and also have been interpreted to permit programs designed to improve racial equity. Next slide. So now I'll move from the statutes to some of the important legal cases. The Supreme Court has found that the government can rely on race-conscious programs to remedy racial discrimination, although it has found that some challenge programs don't meet the standards. So one case in this realm is City of Richmond versus Croson. There, the Supreme Court analyzed Richmond's contracting program for minority and female-owned businesses. This case is significant because it set the standard for when race-conscious programs can be used by a state or local government to remedy discrimination. The court recognized that a state or local subdivision has the authority to eradicate the effects of discrimination if it can show that there is a strong basis in evidence that discrimination exists. The court explained that for Richmond, if the city had evidence that non-minority contractors were systematically excluding minority-owned businesses from subcontracting opportunities, then it could take action to end that discrimination. Ultimately, however, in that case, the Supreme Court found that Richmond had not met that evidentiary burden. After Croson, the Supreme Court extended this analysis, which is the strict scrutiny analysis, to federal programs in the case of Adirondack Constructors versus Pena. In that case, Adirondack challenged a federal program aimed at remedying discrimination against business owners of color and women business owners after Adirondack had lost a bid for a federal contract. The Supreme Court affirmed again that the government remains free to act against the practice and lingering effects of racial discrimination, and that pervasive, systematic, and obstinate discriminatory conduct justifies the use of narrowly tailored race-conscious remedies, and so sent that case back to the lower court to apply that standard. Next slide. So with respect to education, affirmative action policies have been pretty much challenged from the start. This case has a timeline of some of those key decisions, starting with in 1978, the Supreme Court decided a case challenging the special admissions program at UC Davis's medical school that was designed to ensure that admissions of students from underrepresented communities of color. The challengers argued that the use of explicit racial classifications in the admissions process violated the Equal Protection Clause. Applying strict scrutiny, the court, however, concluded that the educational benefits of a diverse student body justified narrowly tailored use of race in university admissions. However, to be narrowly tailored, the admissions process must consider race among many factors in a holistic, individualized review of each applicant. Subsequently, in 4 other cases challenging race-conscious university admissions, the Supreme Court repeatedly held that it's legally permissible for colleges and universities to consider race as one of many factors in admissions to further the educational benefits of diversity, as long as the admissions process was narrowly tailored to that specific goal. Next slide. So with that history brings us up to a case last term that the Supreme Court decided called Students for Fair Admissions versus Harvard and Students for Fair Admissions versus University of North Carolina, which I'll refer to as SFFA. To briefly summarize what happened, SFFA sued UNC, which is a public university, under the Equal Protection Clause, and sued Harvard, a private college receiving federal funding under Title VI. SFFA argued that both universities' race-conscious policies violated the law. And the Supreme Court agreed. The court held that while Harvard's and UNC's interest in the educational benefits of diversity was a, quote, commendable goal, their goals were insufficiently measurable to be a compelling government interest. So this was a stark departure from the cases I mentioned on the prior side that found that the educational benefit of diversity was a compelling government interest. The Supreme Court also held that the admissions policies were not narrowly tailored for a few reasons, including that in the court's view, the policies had no logical endpoint. The school's use of racial categories like Asian American or Hispanic were imprecise and arbitrary. And lastly, that the school's belief that a person's race in and of itself could influence their perspective or identity, in the court's view, amounted to stereotyping. However, the court also specifically noted that an applicant's race may be relevant and permissible to the extent it had some effect on their lives through discrimination, inspiration, or otherwise. Although in this decision, the court did not say it was overruling its precedent and focused on the policies at Harvard and UNC specifically, the reasoning behind this decision has fundamentally reshaped the law in this specific area of higher education. I'll also note that there have been several lawsuits challenging the alleged race-conscious admission policies in medical schools that were pending at the time of SFFA and are still pending. And so we'll have to see the outcome of those cases in light of this decision. Next slide. So the SFFA decision has emboldened many opponents of civil rights to try to challenge both race-conscious and race-neutral programming designed to address barriers to access in education, healthcare, and other sectors. So we want to be very clear about what the Supreme Court did say and what it did not say in that decision. First, the court did not say anything about when the government or organizations that receive federal funding can consider race outside of the higher education admissions process or to advance goals other than diversity. The decision, in fact, did note that there are still compelling government interests that permit race-based government action, pointing to 2 examples in the opinion. One, remediating specific identified instances of past discrimination that violated the Constitution or statute, or 2, avoiding imminent and serious risks to human safety in prisons, such as in the case of a race riot. Second, the court did not decide anything about when private companies and other non-governmental organizations that do not receive federal funds can consider race. So the SFFA decision was decided under Title VI and the Equal Protection Clause, so it did not pertain to Title VII or Section 1981. Third, the court did not decide anything about when public or private entities can use race-neutral means to achieve racial equality. Indeed, Justices Thomas and Kavanaugh cited race-neutral policies with approval in their concurring opinions and suggested they could be used to achieve the same benefits of racial equality. So with that background, I'll turn it over to Pilar, who will provide an overview of the current legal landscape in light of SFFA.
Thank you, Ariel. Since Students for Fair Admissions, opponents of civil rights have brought dozens of challenges to race-conscious and even some race-neutral programs, ranging from fellowships to scholarships to grant programs in sectors from higher education to employment to housing and also to healthcare. These attacks are not new. As Ariel described, they are a part of a decades-long attempt to divide us in order to limit our ability to ensure equal access and opportunity. Opponents of racial justice broadly seek to delegitimize efforts to ensure racial equity in all spheres of American life and prohibit the consideration of race in any circumstances. This includes denying the existence of systemic and structural racism in institutions, as well as denying the legacy of slavery and the ongoing effects of racism and sexism in the United States. Next slide, please. In the health equity context, this means challenging the validity of decades of evidence-based research, demonstrating the existence of racial health disparities, denying the impact of the social determinants of health, and rejecting the validity of health disparities apparent in data. Next slide, please. Health equity opponents also seek to chill lawful conduct. For example, groups have sought to eliminate diversity training in the medical profession. They've also called for the elimination of implicit bias courses, cultural competency training, and microaggression reporting in various states across the country. And lastly, opponents of civil rights have sought to prohibit the collection of demographic data, which they deem contrary to the provision of quality and individualized medical care. Next slide. One major strategy of health equity opponents is simply to file meritless lawsuits in an effort to expand unrelated court rulings to various contexts, such as the SFFA decision to healthcare contexts. Next slide, please. Lastly, a sizable goal of health equity opponents is to co-opt civil rights statutes and render them ineffective in redressing actual instances of discrimination. The lawsuits, letters, and other challenges that have been filed to date are a part of that larger plan. Project 2025 describes efforts to upend critical regulations and anti-discrimination protections. Project 2025 proposes to end our ability to challenge and reform policies and practices that are neutral on their face but have an unfair discriminatory effect, hide discrimination by preventing data collection, refuse to enforce any prohibition on sexual orientation and gender identity discrimination based on what we consider to be a flawed legal theory that these laws conflict with the First Amendment, the Religious Freedom Restoration Act, and federal conscience laws. Project 2025 also seeks to use disability rights laws to undermine reproductive justice efforts and weaponize the federal government's civil rights enforcement agencies and direct them to attack state and local governments, employers, and other private parties who attempt to remove barriers to opportunities in their own institutions. Next, I am going to turn to the current legal landscape as it relates to the work that you all do, the health equity work. This will focus on two topics: state legislation that impacts health equity work and legal challenges to a wide range of health equity initiatives. Next slide, please. Next slide. So far, approximately 28 states have introduced 86 anti-DEI laws in recent years, with 14 states passing state laws mostly focused on DEI in colleges and universities. One example is Florida's Senate Bill 266, which prohibits public institutions from funding the promotion, support, or maintenance of DEI programs. This law also prohibits offering any general education course that teaches identity politics or is based on theories that systemic racism, sexism, and oppression are privilege are inherent in the institutions of the United States. Laws like these limit the ability to recruit diverse medical students and professionals, restrict the ability to provide health equity education in colleges and universities, and threaten health equity research in public institutions. We have also heard anecdotally that professors that teach health equity or related topics are being targeted by their universities. Even if these laws are limited to universities and public institutions, the chilling effect is palpable, as many grant funders may potentially demand that researchers avoid using the term racism in their work or no longer wish to fund work that explores the impact of racism on healthcare. These laws may be subject to challenge under the United States Constitution, and some have been enjoined, but the chilling effect remains. We also know that these are not the only bills that have impacts on health equity. 41 states have abortion bans, including 13 with the total ban. 26 states have bans on gender-affirming care. These laws threaten the ability to deliver healthcare to populations that are likely to experience poor health outcomes, thus undermining health equity efforts. I do want to highlight, next slide, please, that there are states that protect health equity work. California, for example, has laws that require nurses to undergo implicit bias training and requires hospitals to provide equity reports and plans to reduce healthcare disparities. Arkansas enacted a law creating the Healthcare Student Summer Enrichment Program for underrepresented student populations, which is a 6-week program that exposes students to the healthcare field. Other states have laws requiring at least some healthcare workers to take implicit bias training, as I mentioned, California, and it also includes Maryland, Michigan, Minnesota, and Washington. Next, I would like to turn to the spate of lawsuits and complaints that have been filed since the SFFA decision. Note that most of the programs challenged sought to increase the representation of specific underrepresented racial groups in the healthcare profession, medical schools, and academia. Others sought to improve patient outcome among specific communities of color. Most of the challenges I will be discussing allege violations of Title VI and Section 1557 of the Affordable Care Act, which, as Ariel mentioned, applies to recipients of federal funds. That can include hospitals or even private entities. Opponents of civil rights generally believe that any institution or healthcare program that benefits specific racial groups, even if they are in need of a particular specialized assistance, automatically violates Title VI or Section 1557. They also apply this theory to governmental entities they accuse of violating the Equal Protection Clause. Opponents also believe that private entities that use specialized benefits to recruit underrepresented minority candidates of color into their workforce violate Section 1981, the law that prohibits discrimination in contracting. However, broadly speaking, all of these laws prevent institutions to redress the past effects of race discrimination through race-conscious programming or affirmative action initiatives, provided there is sufficient data and evidence demonstrating the program is needed and accomplishes this goal. Amalia will say more on this later. Notably, no court has yet determined whether many of these healthcare programs actually violate the law, as the cases have either been dismissed or settled shortly after the lawsuit was filed. Now I will turn to examples of challenges to efforts seeking to increase the numbers of minority in the healthcare profession. Next slide, please. In Do No Harm v. Pfizer, Do No Harm alleged that Pfizer's diversity fellowship program violated Section 1981, Title VI, and Section 1557. That program seeks to attract specific racial groups to its workforce. That case was initially dismissed on standing grounds, and Do No Harm has now appealed for the second time. The program is still in effect. In Do No Harm v. Vituity, Do No Harm alleged that a physician practice group that sought to recruit Black physicians by offering a $100,000 signing bonus violated Section 1981 and Section 5057. Vituity settled that case and now operates a semi-race neutral program that provides loan forgiveness of $100,000 to new physicians from underrepresented communities who have actively addressed healthcare disparities and discrimination. Similarly, Health Affairs settled a Title VI challenge to its diversity fellowship program and now operates a race-neutral program called the Health Equity Fellowship for Trainees. That program has the purpose of increasing the quantity and quality of manuscripts published on the topic of health equity while cultivating future equity research leaders. Next slide, please. Next slide. This next set of cases addresses challenges to programs that increase minority access to medical education and the healthcare profession. In Do No Harm v. Edding, Do No Harm challenged a minority healthcare scholarship offered by the Arkansas Minority Health Commission. There, parties agreed to terminate the scholarship unless it was administered in a race-neutral manner, and the state withdrew the scholarship altogether. Do No Harm also filed several other complaints with the Department of Education's Office of Civil Rights, which investigates claims of racial discrimination at colleges and universities. The complaints alleged various medical schools violated Title VI by offering scholarships to specific racial groups who are underrepresented in the profession. Baylor's medical school settled its investigation by removing racial eligibility requirements for a scholarship program, but still emphasized it was meant to promote a diverse and engaged workforce. The University of Pittsburgh's medical school settled its investigation by removing racial requirements, but maintaining that applicants should have an interest in diversity and medicine initiatives. Do No Harm also filed an OCR complaint against the University of Minnesota for its pre-health student pathways program that included a racial eligibility requirement. The school also removed that requirement, but still offers the program to first-generation college students and economically disadvantaged students. I would like to note here that challenges against minority scholarships are nothing new, with the first court challenge occurring in 1976. The first Bush administration declared them illegal in 1991, then the Clinton administration declared they were lawful in 1994, and while they are generally permissible if justified with sufficient data and evidence, the amount of legal challenges to minority scholarships often depends on the political and legal climate at the time. Lastly, opponents of health equity have filed several complaints against programs meant to address racial health disparities. For example, a complaint filed with the Department of Health and Human Services Office of Civil Rights alleges that the Cleveland Clinic's Minority Stroke Program and its Minority Men's Health Center are discriminatory. The complaint alleges that these programs violate Title VI because they create a racial dichotomy under which patients are prioritized and cared for. This case is under investigation. Another case, Katabi v. Lawson, alleges that a California state law requiring implicit bias training in medical education courses violates the First Amendment. That case was dismissed as having failed to state a plausible First Amendment claim. Mississippi v. Becerra challenged a CMS payment model that incentivizes providers to develop anti-racism plans. The district court in that case found that plaintiffs lacked standing to bring the case, but is permitting some limited discovery to allow them to make their case. Finally, there has been a challenge to California's Abundant Birth Project. That program provides $1,000 per month to Black and Pacific Islander pregnant people. That lawsuit alleges the program violates the US and California equal protection clauses and Title VI because it is limited to Black and Pacific Islander pregnant people. There have been no briefs filed or orders issued in this case in the year since it was filed. I will now turn it back over to Amalia to discuss what all of this means for the critical work that you all do.
Thank you, Pilar. Next slide. And next slide. So what does this all mean for health equity work? Next slide. So first, as you can tell from the overview that Pilar provided, these cases have actually not changed the law governing health equity programs to date. Several of the legal challenges that have been filed have failed because the plaintiffs could not show that they were injured, and others settled at early stages before a court actually got to the legal questions about whether the programs were lawful or not. And the key takeaways are still the same. Race-neutral programs are still lawful. This category includes programs that aim to serve people in underserved neighborhoods or zip codes, provided that their services are available to all, as well as many DEIA programs. And I'll weave in a quick answer to one of the questions in the chat here. You know, the question of whether something is race neutral or race conscious, again, is based on the mechanisms and the means that are being used rather than the goal. So if the means are race neutral, if you are, for example, trying to achieve a workforce that actually represents the full breadth of talent in your community, and you're using mechanisms like, ensuring that your applicant pool for positions reflects that diversity, that you're offering mentoring programs and employee resource groups that are open to all, but really ensure that people can stay in their work and feel included in the community. Those would be considered race neutral, even if the goal is ultimately to achieve racial equity. Race neutral programs also include funding for research into health equity generally and the health of particular populations. We see in the health affairs settlement even that the plaintiffs who were challenging that program agreed to allow, continued investment in those key areas. And finally, race neutral programs include scholarships, fellowships, and other programs where candidates must demonstrate cultural competency or commitment to serving underserved racial groups. Again, like in that perpetuity case that Pilar was talking about, where the program shifted to, instead of focusing on the identity of the people being hired, to identifying that commitment to serving underserved racial groups. Again, the law also has not changed insofar as race-conscious programs will continue to receive additional scrutiny. And, the legal counsel at any institution should carefully exist those existing programs for compliance with the law and be able to explain with supporting evidence the need for those programs. But the threat of frivolous litigation from opponents of civil rights should not deter anyone from their mission. As opponents of civil rights try to undo the racial advancements we've made in this country, we need organizations committed to racial justice now more than ever. And this is fundamentally a moment to recommit, not to pull back. That means, looking at the lawful means that we know can justify race-conscious programs if that is something your organization wants to invest in. For example, remedying discrimination. Proving that discrimination requires collecting data to demonstrate a compelling need for the program, exploring, a race-neutral version of the program and documenting how it falls short or fails to redress the problem, which can help demonstrate why a race-conscious program could be needed and therefore lawful. And in general, if a program has rules that are transparent, fairly enforced, and accurately reflect the available evidence, that program is more likely to survive that heightened scrutiny that it will receive. At the same time, we have seen opponents of civil rights successfully change the behavior of particular programs and shift the public narrative without actually changing the law. We've seen scholarships and fellowship programs alter their criteria, schools close DEIA programs, change their admissions practices, and decline to disclose or collect admissions data at all. And funders pull back from grants to organizations led by and serving people of color, oftentimes unnecessarily. Importantly, as organizations are doing that, healthcare organizations, employers, schools, and other entities still have those existing obligations not to discriminate that Ariel outlined earlier. And organizations that roll back programs that ensure equal access and opportunity for patients and providers risk erecting new barriers, opening themselves up to possible discrimination claims. What that means is that the risk is not one-sided. While our opponents are trying to shill lawful conduct designed to increase racial equity, in doing so, if you roll back your programs, you could actually risk violating the law by discriminating against the very populations that you would seek to help. Next slide. So what can we actually do to protect health equity work? Next slide. We cannot accede to our opponent's zero-sum vision of equality, which frames any attempt to open up access for one group as taking something away from others. We know that to ensure equitable access to healthcare for underrepresented groups and is essential to create the pathway to a healthier, more productive, and more fair world for all of us. There are a number of things that health equity professionals can lawfully do to protect and advance this important work. Which lawful policies and practices make the most sense It depends on the mission of your organization and which strategies are most effective at achieving your goals, understanding the current legal landscape. So, for example, if you want to increase equity for patients, you can look to increase language and physical accessibility, such as providing patient materials in multiple languages, providing translators, and other mechanisms. You can continue to invest in efforts to foster cultural competency through trainings. Effective trainings can help providers learn the skills they need to build trust with their patients, including patients from all backgrounds, and to more accurately assess patient histories and needs. And healthcare institutions continue to seek out providers and staff who have experience with and dedication to working with underrepresented populations. This process can include asking prospective providers about their experience working with underserved populations and screening candidates to identify those who have a demonstrated commitment to working with underrepresented communities, among other measures. Next slide. If you're hoping to create more equitable environments for providers, you can also do a couple of different things. First is to build robust pipelines and engage in active recruitment. This can include everything from encouraging all personnel to actively participate in recruitment activities, ensuring that your organization's representatives attend career fairs at HBCUs and other minority-serving institutions, and as well as universities that serve a disproportionate share of students from communities that are underrepresented in your applicant pool. Arranging for your organization to recruit through student organizations or professional organizations that serve underrepresented candidates, and consulting with professional organizations that support professionals in that underrepresented community. You can also establish aspirational goals to address the underrepresentation of excluded groups through lawful and effective initiatives. It goes to that question that was in the Q&A that I tried to address before. Aspirational goals can provide a lawful guidepost for whether an organization is achieving equity, as long as you are trying to further those goals using permissible measures and not actually imposing a rigid quota. You can continue to foster an inclusive work environment by evaluating all of your policies holistically to figure out what's actually creating barriers to opportunity and retention of providers. From making sure that your policies allow for workers with caregiving responsibilities, accommodate religious garb, cultural and natural hairstyles, and fluid gender identities, and enable people to bring their full selves to work. And finally, you can also continue to invest in employee resource groups and mentorship programs that are open to all, including by providing administrative and financial support equally to all of these groups. Next slide. Finally, there are a couple of strategies that are effective at addressing both goals, both ensuring equity of access for patients, as well as equity of access to the profession for healthcare providers. First is really continuing to communicate the value of ensuring equal access to the profession and to healthcare. This messaging should emphasize that health equity is not about quotas, either in terms of providers being hired or patients being served, and should explicitly refute that zero-sum framing of our opponents. As healthcare experts, you know that we've been able to see continued gains in population health, even as we've paid needed attention to individual health outcomes and outcomes among specific populations. And I think really refuting that idea that the benefit to one necessarily means taking something away from someone else is critical to getting out of the box that we've been put in and really trying to ensure that we have broad support for these kinds of initiatives. Next, collecting data on the need for health equity programs and how they improve health outcomes, and on discrimination against patients and providers and how to address it is critical. We need to invest more in understanding what is happening on the ground, what the needs are, what programs are most effective, and to use that data to actually provide the legal, moral, political, and social justification for these programs. This kind of data and research can help address health disparities and employment barriers, and help organizations determine where to invest effectively. For both populations, you can continue to expand outreach to underrepresented groups, such as developing community-based partnerships with organizations that largely serve particular populations, locating mobile clinics or brick and mortar offices in neighborhoods that are underserved, advertising directly to underrepresented groups, such as going to job fairs and sharing job postings that I discussed before, provided that those techniques supplement rather than supplant other ways in which your services are advertised. The goal of this kind of targeted outreach should be to increase the number of participants and applicants from the populations you want to serve, rather than to narrow the pool only to people of a particular race, which is likely to receive heightened scrutiny. We encourage providers to conduct an equity audit to identify and document problems and formulate targeted efforts to remediate them, whether that is identifying why you are not able to reach everyone in your community and serve them effectively, or to identify what are the practices within your own workplace that are creating barriers to talent in your organization. We encourage folks to modify the application process for research and other funding to identify similar kinds of artificial barriers, make it harder for everyone to compete equally, to continue to advocate internally and externally for continued investments in health equity work, and to diligently comply with anti-discrimination laws. In closing, our opponents of civil rights are seeking to divide us. They're trying to do so because they know it's the only way they can maintain unpopular policies that frees America's radically unequal status quo. We can overcome the challenges we face now by coming together with a robust response from all of us. I'm happy to answer questions.
Thank you, Amalia, Ariel, and Pilar. That was just tremendous. Yes, claps all around. We have so many questions that are coming in. I know that I have so many questions. We're going to start with the audience Q&A. And so the first one that was posed is, what is the best way to stay up to date on potential legal challenges and or protections for organizations who are implementing health equity work? Do you have any resources, strategies, toolkits that you can share with us?
Yes. So I think maybe I can lean on the Health Equity Community Collaborative folks to circulate some links to our attendees afterwards. There are, in addition to our website, which talks about the work that we are doing, there are two resources I would point you to. There is both an institute at Georgetown that is tracking health equity cases specifically. And then there is the Meltzer Center at NYU, which is tracking the broader legal landscape, including some of the challenges that are likely going to shape the law in health equity cases, but may not directly touch on health as the focus of the program is being challenged. And I'm happy to share those links.
Okay. Thank you. So I really appreciated the last bit about all the strategies and kind of counter moves that we could be making. And so the next question is in that vein. So have you seen any, and if so, please let us know what they are, effective communication campaigns that have continued to advance health equity work in the face of really strong local opposition?
I think this is something where we're continuing to develop our toolkit. I think the things I have seen to be most persuasive are two different pieces, because we know that not everyone is persuaded by the same kinds of information, persuaded in the same way. I think one bucket of work is really that like hard data and the statistics that demonstrate the need for these programs, which are compelling to people who approach the world with that kind of mindset. At the same time, I think collecting stories about the impact of programs is essential. I think it's something that we need to do more of across racial equity work, and really use it as a counterweight to some of the framing and the negative stories that we're seeing from opponents of civil rights, to say, you know, this was my experience. This is how having access to this program actually led me to connect with a doctor who was able to better serve me. This is how this program in my workplace actually allowed me to succeed in a way that I might not have been able to otherwise. I think above all, one of the things that's been consistent across successful campaigns is really emphasizing that, when you're addressing racial equity issues, even in those cases where you are targeting particular groups, because that is where the need is, that's where the discrimination is happening, that's where the disparities are, to recognize and bring people back to the fact that those kinds of programs benefit all of us. That we are losing out on the skills and talents of individuals. We're losing out on trillions of dollars in the US economy. We're losing out on, the just having a community where everyone is able to thrive if we don't actually invest in these measures. And that's the world that I think we want to live in and that we can call people to join us in.
So you're speaking my language. So again, I'm a population health scientist and a program evaluator. And when you put up that slide, I forget who put it up, that said, here's all the ways in which the evidence that we all know, the truths, whether it's the existence of inequities, the salience of social factors and health, right? Folks can just say, no, I don't believe that, or I'm going to discredit that evidence. And I've seen some folks in the chat say the same thing. Most folks aren't persuaded. You've just mentioned, Amalia, I think, kind of alluded to the power of narrative and storytelling as a supplement to some of that more quantitative data. And I think you also pointed out, a phrase that I often say, kind of, what are the metrics that matter, right? Who needs to be persuaded? Like, you don't need to persuade me of the value of this work or the need for this work, but there are many folks that we have to persuade that are really adept at kind of ignoring evidence that doesn't, I guess, fit with their worldview or their biases. So before I turn to the next question, just to follow up, are there pieces of evidence, that would move us from kind of the heart validity and soul validity and gut validity of this work, really to that scientific internal validity that would be more difficult to dismiss? Is it a combination of story and data, or is there research that my community could start doing immediately to kind of provide you with the tools you need to make an even more effective argument than the one that you're already making?
I was pausing to see if either of my colleagues were going to jump in. And so I think that there's a combination of things. And part of it depends, again, like the point you were talking about, like, who are we speaking to in this case? Because there's evidence that we need for legal justifications, or that could be useful from a legal framework, which is my background. I'm not a communications professional. When I'm talking about successful comms plans, I'm basing it on message testing and the wisdom of my colleagues who really know that world. And also just, my experience talking to friends and family and others in the world. From a legal standpoint, I think that there is a lot of work to be done, really connecting the health outcomes that we're seeing with the actions of the government and of private parties in creating those outcomes. So some of that is, historical research. Some of that is additional, population-based health research. So that's one area that I think we can continue to invest in. But also, I anticipate that either my colleagues here or there might be others attending this webinar, given the wealth of experiences, that might have additional thoughts.
I would just reemphasize the point that Amalia was making. So many of these programs actually could withstand strict scrutiny analysis, meaning that really close look at the program, if they kind of did that extra work of making those connections. And so the Supreme Court has said that we really want to connect the program that we're implementing today with the discrimination that we're actually seeking to remedy. And so I think we all start with this great goal, like, oh, we want to increase numbers of Black doctors at this hospital, which is great, but really doing that extra work of explaining and doing that data collection, that evidence gathering, so that in the event that your program is challenged, it can withstand scrutiny by a court. And I just think that's the missing piece. And it's not that it doesn't exist, it's just that people don't know, like, oh, okay, if I want to have a program that accomplishes this goal, I need to make sure that it complies with the law in this specific way, with this evidence that I need. And yeah, I'll just leave it there. I think that really is kind of like the hole that we're seeing in a lot of this work.
So as you can imagine, there are many motivated folks in our audience today. And so we have received a lot of questions wanting to know some variation of what can I do, which I think you've touched on in various ways in the presentation. But we had, I think, a couple of questions about what can someone do as an individual, right, to protect these health equity programs? Is there anything that individual citizens can do to exert pressure, particularly on local and state and even federal lawmakers?
So I am somewhat limited in what I can say because we are not here to encourage grassroots lobbying. But I think, using your expertise to document the need for these programs, being willing to speak out in favor of them, to come to their defense. At the same time, also making sure that you're taking a hard look at what you're doing and making sure that it's achieving the outcomes that ultimately we want. I think we need to make sure that we're investing and devoting our resources to programs that are effective at creating the outcomes we want for patients and for providers. And then, touting those successes, as broadly as possible, including engaging internally in your organizations and externally with other entities.
And I would say too, I think we're seeing so many organizations just pull back because there's a threat. And just because there's a threat of litigation doesn't mean that you're in the wrong. And it also doesn't mean that you'll be sued, but even if you were sued, it doesn't mean that you would lose. And so, I mean, we are all constantly walking around with the threat of litigation. We might, invite someone to our house and our neighbor trips and falls in our doorway. I mean, there's always this threat of litigation in our society. So that doesn't mean that, we just have to be so fearful. And what we've seen is after SFFA, all these people, all these funders who were so progressive just 2 or 3 years ago, suddenly were like, oh, we can't do this anymore. Why not? Who told you that? Who said that? And of course, there's the risk, we have to, each organization should evaluate its own risk tolerance, but also, from our perspective, as lawyers, we also want to make sure that we're not creating bad law. But that doesn't mean that we want to completely say, hold up, don't do this. And so when we ask, like, what can I do as an organization within your own risk tolerance? And it's not legal advice, but, evaluate, is this lawful? Probably. Did someone say I can't do this? No? Okay, well, continue on. And I think that really has been so much of the effect that we were talking about throughout this presentation. Is the chilling effect. It's just the fact that someone said boo, and now you're saying, okay, we won't do it.
Yeah, it was a really powerful boo, right? And that boo, I think, was louder in some states than in others, which certainly impacts. I think there are lots of questions about funding and kind of what funding folks can take, and if folks, in certain states that are receiving funding for EDI or health equity work, that might be in some way verboten. So, is there any way that funders can protect and sustain grantees who are doing this work amidst, particularly like state legal challenges? Or federal legal challenges?
I would, go ahead. Sorry.
Well, I think kind of building on what Pilar's last point, there's a question about risk tolerance. And again, we don't want to provide legal advice to a specific funder, but, we went over the requirements about, Title VI and accepted government funding and whatnot, and making sure, if it's a race conscious program, that it can meet that strict scrutiny standard, but that's a really specific kind of, you'd have to look at the circumstances you're dealing with in your specific case. But, race neutral programs, there's nothing that says, you're doing a race neutral program that you can't continue funding that type of work. And but I think this is the point of where, you don't need to reflexively be scared to continue this work, but it's about looking at, your specific case, seeking legal advice if you're worried that you're maybe on the line and you might be subject to a challenge. But even if you are, doesn't mean that you actually are violating the law or at any actual legal risk.
I think I would add to that, there was a question in the chat about the Washington Post article about funders pulling back from anything that says they're looking at racism. Looking at racism is not itself a race conscious action. You know, identifying the way in which race impacts people's life is needed, and I think would be well suited to satisfy scrutiny under the many different regimes that Ariel and Pilar talked about. I think what we're really seeing is this chilling effect, that because our opponents are targeting certain kinds of programs, we're seeing people pull back from anything that even mentions race, or organizations that are seeking to serve particular racial groups when that's not actually required by the law.
Yeah, I would say the original question was, how do we protect these funders, or how should funders protect themselves? I mean, I think the first step is, does this law apply to me? You know, does this DEI law targeting colleges and universities, does it apply to me as this like private funder that's using all of my own personal money? I'm Bill Gates. You know, why would this law apply to me? And then also, even if it did, does it apply to, as Amalia was suggesting, does it apply to this action at issue? You know, that is who said that talking about racism in a research paper is a race conscious program? So just taking a breath. I think that's kind of just like taking a breath, don't freak out. And just to kind of, reiterate, so many of the cases that we highlighted in our presentation have really gone nowhere. They've been dismissed, or they settled, and, and a lot of the cases that I highlight that settled, that law has been decided on, minority scholarships and things like that's already kind of it's low-hanging fruit for these people to go after. I'll say that. And so don't take the fact that like this recency bias makes it seem like there's a sudden explosion and against like minority scholarships, for example, when this is already something that's been decided, and they're just using this for like public relations purposes at this point.
That is a golden piece of advice. If there's anything we all walk away with from this webinar, beyond the desire for all of your slides so we can dive in more deeply, it's take a breath, is that there is a path forward. So thank you for that, Pilar. There was another question, and I'll answer it first, so I guess it's a little bit selfish, but then I'll turn it over. So folks are asking, is there research about how universal policies, I guess by that we are talking about kind of more race-neutral policies, could actually benefit more, one group more than another, and help us achieve racial health equity? So, from our Center for Health Justice, we did some research a few years back looking at paid parental leave and the impact of a paid parental leave policy at the federal level would have on racial, ethnic, maternal health, mental health inequities. And while that gap wouldn't close, there was absolutely, for sure, a racial justice impact from a universal policy of providing paternal leave in a way that creates opportunity for health and well-being for everybody, but differentially for one group more than another. So absolutely, whoever posed that question, there are examples of that in the literature, but I wonder if our colleagues at LDF have any examples that have been particularly useful in their thinking about the importance or the viability of race-neutral policies to achieve our common goal of racial health equity.
Yeah, I think there are numerous examples like that, not just in the health equity space, but in the workplace and the higher education space. I think one of the things that I think about in this landscape is that, one of the points that you were making, Dr. Aberti, which is there's still that gap where we might be able to get to 80% of a solution, but there are still sometimes cases where the race neutral option may not actually address the full racial disparity that we're seeing. And I think that's the space where we need to be thinking about, what else we can be doing, whether that's including additional race neutral measures to continue to close that gap. And also, I think why LDF is still invested in defending the viability of race conscious programs, because when you're combating racism, the best solution may be to address the racism, not to address the symptoms of that racism as they show up in other places.
So this question is getting a lot of play in the Q&A box. So given the current Supreme Court and the makeup of some of the circuit courts, how do you think about the risk of creating bad precedent in this highly litigious environment?
I think we think about it long term. LDF has been fighting these battles for more than 80 years, which is long enough to have one Brown versus Board of Education, and then to see it be co-opted and eroded by the Supreme Court and the circuit courts. So I think, it's about figuring out what are the cases that are worth fighting, where the law or the district court has made a ruling on the facts. And we think the facts should support, the program that's being challenged under existing law, and, being thoughtful about the fights we want to fight, knowing that sometimes the loss in court actually advances the larger public narrative goals. It advances the possible legislative goals and other things. But it's also a really hard time because the courts are not friendly to these challenges. And it's going to be a long-term process, I think, to identify what are the effective legal arguments that we need to be bringing, and to start building those from the ground up, as well as building the evidence base needed to support race-conscious programs in particular.
So I'm going to pose one final kind of round robin, quick response from all of you before we turn it back over to our colleagues at the Health Equity Collaborative to close us out. But if there's one thing that you would like the audience to remember from this conversation, what would that one thing be?
For me, it's that the laws that the opponents of civil rights and health equity are using also do support the work that you are doing. But we encourage you to seek out organizations that may provide you with further information about how to make sure that your program is sufficiently supported by evidence and the right kinds of evidence, and really are thinking through, how would my organization survive a strict scrutiny challenge, or how would my organization survive evaluation under Title VI? And so we've talked about what those general requirements are, a few times, but really just making sure that you understand what those are so that you're doing that work. But ultimately, that each of these laws provides a mechanism for you to do the work that you like to do.
Thank you, Pilar.
Yes, I would say that this is kind of a cyclical pattern, that this type of backlash to health equity work, racial equity work is not new. It's been ongoing. And that doesn't mean that there is a current type of backlash looks one way. It means it should stop. And this is an ongoing process. And, as Pilar was saying, there are still the tools to legally support this work, which is kind of the area that I come from. And so just to bear that in mind, that this doesn't mean that you have to stop all your work, and that it's no longer permissible. It just may have to take a different form, or there may be different legal challenges that we'll have to overcome.
Thank you, Ariel. Last word, Amalia.
I think Pilar said it best. Take a breath. We know that these programs are worth investing in. We know that they are important to our vision as a country. And that ultimately, I think that will win the day, and we can call people into that vision. What we need to do now is take a breath, recognize that we're again in a moment of retrenchment, and keep fighting.
Thank you so much. Please join me in one more additional round of applause for these incredible panelists. Much appreciated. I have learned so much. And back over to you, Jacqueline.
Awesome. Thank you, Philip. And thank all of our speakers today for sharing their expertise with us. Fantastic. There's been a fantastic Q&A session. I always just want this to go on and on, but I have loved every moment with Dr. Alberti really kicking us off with thinking about equity 3 ways, and really just showing us, like he said, the process is as important as the product. especially when he demonstrated that through showing that a look at some policies receive more pushback when they're promoted as racial equity initiatives. And especially with the LDF team's informative presentation, I know I'll have to revisit that information, but just so much information allowing us to really recognize how to differentiate race-conscious programming versus race-neutral programming, talking about the different legal challenges that we've seen so far. And I think what stuck out to me is just that major takeaway of that even though there are no laws governing health equity programming, we still see so much fear that is spurred, as well as changes in programs and changes in behaviors based off of fear that is spurred just through the opposition of those programs. So I just want to say, thank you, Dr. Alberti, Ariel, Amalia, Pilar, for your incredible insights today. Our hope is that these presentations gave you, all of our attendees, the ability to really strengthen and continue the work that you are doing. I saw so many people mention in the chat, just keep going, right? That we should just go stronger. So I hope this allows you to continue your work confidently, whether you're a funder, whether you're implementing programs, whether you're just advocating for programs, that you can continue ongoing racial equity efforts and avoid any risk or threats to your programming. We have just launched a Zoom poll, so please take a moment to fill that out, as well as the evaluation when it pops up when you exit Zoom. That will help us out greatly. And then we do have a few announcements that we want to mention before we wrap up today. Recently, you all know this summer, the Health Equity Community Collaborative launched a belonging survey, and we still have that survey open. We definitely like to get some more insights. Of course, we've gotten a lot of great feedback from our members, but we really welcome anyone to complete the survey. We are particularly looking for responses from those representing healthcare, the healthcare sector, or those within director level positions. So if that's you, please take a moment to fill out some responses there on our belonging survey. Health Leads has also released recently a survey around artificial intelligence, or AI. So we want you to be aware of that survey, which will also help us out. This is a really brief survey. It only has 3 questions, so it'll take you less than 5 minutes to complete that survey. And then lastly, we want you to please save the date for our post-election fireside chat conversation, which is happening on November 5th. I just want to make sure I got that date right. So please save the date for November 20th. We'll be sharing out more details with you in future newsletters. But again, I just want to thank you all for your attendance today, your engagement. The questions have been amazing. So just thank you all. We will be sending out a copy and a recording of the slides, as well as all the resources and links that were mentioned today to all of those who registered. And yeah, we just want to thank you and wish you all a great day, and we hope to see you back next time. Thanks, everyone.